rise. Appeal for judgment to Lady and Senior Graduate Metropolitan District Council.
For the reasons given in the judgment which I now hand down, the appeal is dismissed, the appellant's application for permission to appeal to the Supreme Court is refused, and there will be no order as to costs.
Appeal are heard in the matter of Cuadrilla Bowland Ltd and others, and Lawrie and others.
My Lords, we finished yesterday by looking at what Lord Justice Longmore was meaning by the expression that there should not be reference to intention in injunctions of this sort, paragraph 40 of the judgment there. And your Lordship have my submission that when contrasted with what's said about paragraph 42 about when such injunctions may be appropriate, that whatever Lord Justice Longmore meant by should not, it doesn't mean in absolute terms. But for the purpose of this ground of appeal, my Lords, the point I think I need to make is a rather narrow one, which is that whatever is meant by should not, or the prohibition which is to be inferred by should not, it's not because such a reference to intention makes an order too uncertain for the purpose of enforcement by committal. And just before I leave this, my fifth head of submissions, and without wishing to go back over old ground unduly, I was concerned overnight on reflection that in the context of talking about criminal mens rea, I think I was possibly too reluctant to say, you seem to be saying anything too obvious, and in that reluctance, I don't think I quite made the point I was intending to make. To your Lordship's indulgence, I wish maybe that briefly. We were looking, and I'm not going to go back to the case, but we were looking at it in the Attorney General and Punch case about what was required for certainty of a court order in a common law committal context. And the test was set out in paragraph 35, tab 6, authorities right. We then looked at the Sunday Times case, and that was a case in a human rights context, again in reference to certainty of civil court orders as to what prescribed by law meant for the purpose of derogation from the principle of freedom of expression under Article 10.2. And the test is set out there, paragraph 49, in my submission is materially identical to that in Punch. It's the same concept. Then the third point in this triangle I'm seeking to set up is that we looked at the Lithuanian protest case, the tractor protest case. That was a 10 of the authorities Bible. And that quotes the test from the Sunday Times case verbatim at paragraph 109. So the point I'm trying to make is not simply that the criminal courts don't have a problem with intention, but that what is sufficiently certain for restriction on freedom of speech to be allowed in a civil context seems to be the same as that is allowed in the common law, sort of criminal context on one hand, the same as the civil law, common law, contempt of court jurisdiction on the other. And so if references to intention on the former fall foul of the certainty test, so too in the latter. And that would mean my submission is taken to its conclusion that criminal offences with intention committed in a protest context could, if my learned friends are right, not readily be enforced by criminal sanction. In my submission, that must be wrong. So that was the slightly more subtle point about the role of the criminal law there. Moving then to the sixth category, to look briefly at just 4 cases which skirt around possibly some of the issues a bit more discursively. Like your Lordships, I think, I had understood that the only ground challenge to the order was by reference to intention. There was a suggestion by reference to Lord Justice Longmore's tentatively framed requirements that there may also be some form of challenge as to whether or not the injunction sufficiently mirrored the prescribed tort, and so I'll touch upon that in what I'm going to say under this head. And the point of these 4 cases, my lords, is this by way of introduction. And I think it picks up a point that was made by my lord Justice Leggatt yesterday about the difficulties of being unrealistic to say that the court is powerless to provide civil remedies to prevent direct action protests in a process of this sort. And in my submission, that is, with respect, correct, that can't be right. But it does focus on a difficulty which the court has to grapple with. And that is that in my submission, those who reject these orders ought not to be able to have it both ways. On the one hand, one can try to tailor an order to the precise ingredients of being taught, making it very detailed and very prescriptive. But that would be faced with the complaint that is then too difficult to understand, too complex. On the other hand, one can try to make it simpler by cutting out elements like intention or effect of conduct and focusing it instead on particular acts. But that would make with the complaint in some cases restrain actions which are ultimately legal. And plainly in my submission, the courts must strive to avoid restraining lawful acts. But in my submission, the court will, within limits, be prepared to tolerate that risk where there's a balancing exercise that requires it. And in the case of interim injunctions of this sort, my submission is the balancing exercise must recognise that the...
So when you say interim injunction, did you say interim
I did
injunction?
say my submission.
But surely it's irrelevant whether they're interim or final.
Well, say for this point, my lord, that in the balancing exercise, one has to recognise the risk of harm to those being restrained by lawful from performing lawful acts or acts which may be lawful. This injunction does have a cross-undertaking damages. So there is that balance built into it. There is a liberty to apply on 48 hours notice, should anyone feel that their rights are being restrained unduly.
But that's a sort of logical accident, isn't it? I mean, in principle, I haven't even focused. I've rather assumed that the order of 18th of July, whatever it is, the one which 11th of July has been breached, because the breaches occurred so soon, it was still an interim injunction. Is that right? Was it never turned into a final injunction?
Still an interim injunction.
Why is that?
That's, my lord, because following the mechanism that was put down by the Vice Chancellor in Hampshire Waste, the listing of a trial without law was not provided for. Instead, it was subject to a long stop vote and with liberty for any person affected to file an acknowledgement of service to set in train a motion.
I see. So this is a particular... I'm sorry, I just hadn't focused on this. It hadn't seemed to matter. You're saying this is a feature of persons unknown injunctions, that it's a bit pointless having a trial because there isn't another party to have the trial against. So the interim injunction goes on forever.
It doesn't go on forever.
Well, right, it has a different mechanism for bringing it to an end or for having it reviewed.
It has a long stop date.
It has to have a time limit.
Yes, it has to have a time limit. It has a long
Yes,
stop
sorry,
date.
and this is all coming back to me. I just
Yes.
haven't thought it through.
But because it's
Although it is not at all unusual in these cases that there are named defendants, and in those cases, presumably you do proceed to a final injunction.
the mechanism in this case provided otherwise, my lord.
Yes, but I'm just trying to think about this as a matter of principle.
As a matter of principle, the way it dealt with here was that my clients were very clear that they named people who seemed to have a particular interest, particular involvement, but were not seeking to single them out more than anyone else who might be trying to.
And they wouldn't welcome a final hearing, just means more cost.
Yes, so the opportunity was afforded to them to file an acknowledgement of service and take it to trial should they wish. But equally, they were given the option that they could simply be treated in exactly the same way as persons unknown and not compel a final
Yes, I see.
hearing.
Is that all makes sense? Is it clear from the case law that I don't need more about the universal practice, but the general practice in these cases where there's a mixture of persons unknown and maybe a few named individuals with a particular interest, is that the what I'll call the Hampshire Waste principle, that you don't bother with a final proceeding to a trial, is what is normally followed? Or are there cases where there is a trial of the injunction, a trial of the claim for an injunction leading to a final injunction?
Certainly, my lord, there are cases where there has been a final hearing. But what I don't know if that has been because somebody named has compelled it, or whether it has been set down on that motion because the judge has nevertheless thought that appropriate.
Anyway, it's a matter of management of the proceedings, really.
Well, it is. It's set for this, that insofar as you're relying on the fact that as a point of principle that there will be an undertaking in damages and so on, that wouldn't be present if there was a final injunction.
My lord, cross-undertaking in damages wouldn't usually, of course, be present in final injunction, but one might say that it should be, and if in a final injunction gets persons unknown.
That would be quite contrary to principle, wouldn't it? Because at trial you have established your right to the injunction, and you only have a cross undertaking in damages because you may not establish your right at trial.
My lord, yes. If I may use, not dodging the question, if I use a different example, the case I'm going to come and look at,
Right.
that the liberty to apply is typically also a feature of an interim injunction as well.
Absolutely.
But
Normally needs to be a change of circumstances.
normally, yes. But what is said over to, I forget, Lord Justice Scheinman, I think it was, in one of the cases we'll come to, is that where there's final relief, which may risk going wider than the strict tort to be restrained, there ought, even in a final injunction, to be liberty to apply. And so the submission I'm making is that if one is trying to tailor flexible relief against persons unknown, even on a final basis, it may be that greater flexibility is required.
Well, especially as they may not exist at the time the final order is made, in the sense that they don't fall within the class at that time.
My lord, quite so. I should say, for completeness, that in the Canada Goose protest case, that was a case concerning protesters outside the Canada Goose store on Regent Street, I believe, the claimant in that case, having got an interim relief against a person unknown, applied for summary judgment.
Yes.
And the judge, I think it was Mr. Justice Nicklin in that case, or Nicklin, was concerned with how one shows that persons unknown who don't exist can be said to have no reasonable prospect of defending the claim. And there is quite lengthy discussion in that case about the difficulties, as the learned judge there saw them, about principles of this sort. And I know that there's an appeal outstanding against that decision. But one of the points that troubled the learned judge in that case very much was the problem of the sort of mechanisms I've been talking about, namely liberty to apply and so forth, cutting across the general principle of finality in litigation. And in my submission, to treat finality as being an absolute principle, again, is being too absolutist, and respect to the judge in that case, he was wrong to be so focused on that, because yes, one wants to achieve finality, one also doesn't necessarily want to have interim injunctions ticking along too much, but equally, one may need an appropriate case in my submission to grant some relief after trial where it may be necessary to revisit it, if that's what the justice situation requires.
Can I, like my lord, I hadn't focused at all on that there was any significance in this being an interim injunction, but just one other aspect. My recollection is that in American cyanamide, Lord Diplock said that in order to obtain an interim injunction, the claimant had to have a seriously arguable case for that relief at trial, which would suggest that the court should not, I may have misremembered precisely what Lord Diplock said, but which would suggest, as seems in a sense common sense, that a claimant should not be able to get a wider injunction, interim injunction, than they could obtain by way of final relief.
My lord, quite so, and with respect therefore to the decision of Mr. Justice Nicklin, if he was concerned that you couldn't grant final persons unknown, it would follow injunction. It would follow that you couldn't have one on an interim basis either, and that seems to cut across what's now established law that you can. And so,
Well, yes, I mean, in the Hampshire waste case, of course, it was an injunction to restrain direct action 2 days hence. So really the point of the trial never arose in that case. So,
But just to come back, the basic point that you were making, and I'm not sure that you can only make it in the context of an interim injunction, is that it may be acceptable, though to be avoided so far as possible, to have an injunction framed in a way that might conceivably prohibit lawful acts. Let us suppose you wasn't an interim injunction, so there's no undertaking in damages. How do you put that as being justifiable? It's a serious thing for the court to say you may not do anything comprised in some general description when there are circumstances where you ought to be allowed to do that.
the way I justify that manual is by reference to the liberty to apply provision, which, as we'll come on to look at, it appears there's a suggestion that it would be appropriate in final injunctions of this sort, because what one is doing there is balancing the risk. Yes, there is a risk of restraining someone from doing something otherwise legal, obviously to be avoided where possible. But if the risk is only that they should be so restricted for so long as it properly takes to have an application to determine whether or not it's appropriate in light of these circumstances that it should continue in that form, that's a price or a balance worth paying. If the corollary or contrary option is ordinarily taught.
so the price worth paying is that citizens are restrained from performing lawful acts by court order.
My lord, yes, it sounds stark.
What power do
stark,
we
but
have to
We were showing
prohibit
yesterday,
lawful acts?
sorry, a case in which that was discussed, weren't we, Burris and...
Yes, I was going to come on to look at that.
Shall we look at we've been very helpful. Yes, look at the cases.
So that's you have the stall that I've set out, and I'm to persuade you right. The first case I was going to look at, I'll take your lordships to, was the JSC Bank and the Abbey Ossoff case that we looked at yesterday.
Yes.
Abbey Aswell.
Abbey Aswell. My lord. That was in the additional bundle of authorities in Tab 4. And this is on a short and slightly different point from one we were just on, but the point here is that my learned friend is submitting that the tort of conspiracy, unlawful means conspiracy, is being stretched to circumstances where it doesn't really belong. But in my submission, my short submission, in fact, the tort in the context of direct action protest cases is much closer to the origins of the tort than the international criminal or the international fraud scheme. And one sees that, my lords, from page 167 of the bundle, paragraph 7 of Lord Sumption. Judgment.
Well, it originates in industrial action cases.
Exactly, my lord. That's the point, and it arises in the context of, as your lordship says, persons taking direct action against industry, which, in my submission, is not all that far removed from what is happening in processes of this sort, where people, albeit not employees or members of unions, that are using direct action in the vicinity of industrial sites to seek to prevent what is otherwise unlawful, or otherwise lawful, from taking place. And so it's not a big leap in my submission to see that the principles that arise in this context could properly be applied to direct action protests. And that's especially so if your lordships would turn on to paragraph 10. But then lordships there set out what it is in a modern context which justifies the basis of this tort. And your lordships will see on the 5th line down that a more useful concept is the absence of just cause or excuse. And that's the uniting feature of the two different sorts of conspiracies talks. And then after the authorities that are cited in that proposition, the judgment continues that a person has a right to advance his own interest by lawful means, even if the foreseeable consequences to damage the interests of others. The existence of that right affords a just cause for excuse. Where, on the other hand, he seeks to advance his interest by lawful means, he has no such rights. And so, in my submission, one can apply that reasoning without stretching it or the tort unduly to direct action protests. People, of course, entitled to express their views, and they are able to express their views even if what they want by their views is to stop an industry, for example. They mustn't do so by unlawful means. So, my Lord, that was the first of the four case elements to take you to.
What is the actual proposition you get from that?
It's not a proposition that's part of the building blocks of the point I was trying to make.
Yeah, I see.
It was
It was basically an answer to Ms. Bremelow's submissions.
My lordship.
Yes, I see.
But they were not persons unknown cases, were they?
That was not a person.
Well, I don't think any of them were. I mean, they're all cases against the union or its senior officials.
My lordship, yes, save that the case I'm going to ask your lordship to look at now to have one of this same bundle, which is the News Group newspapers case.
Right.
Whilst it was, as your lordship was just alluding to, against various unions.
Yes.
If your lordship turn to page 185 of the report, one can see that F of the report, it sets out what relief was sought in the order by the notice of motion. And if your lordships will see that what is sought at 1A was an order that the defendants in each of them be restrained forthwith, whether by themselves, their servants, officers, agents, or otherwise howsoever, inciting, inducing, procuring, persuading, assisting, encouraging, financing, and or in other ways whatever facilitating, at or near the premises of the third plaintiff at Pennington Street, London, E1, demonstrations and or marches and or picketing which involve the commission of an unlawful act or acts, in particular, without prejudice to the generality of the foregoing, nuisance and or obstruction of the highway, interference with trade or business of the first and sixth plaintiffs, and or their commercial contracts, and or intimidation, save except such picketing as was rendered lawful by statute. Being picketing for purpose of peacefully persuading any person to work or abstain from working. Just pausing there, your lordships will see that this is quite a wide injunction as to what is being restrained. And it includes, in particular, at least 3 intentional elements. One, picketing safer where it's lawful, and it's lawful where it's done for the purpose of peacefully persuading any person to work or abstain from working. Second, it restrains the tort of intimidation, which is also intentional, as I'll come on to show your lordships. And third, interference with contracts, which again is intentional. But then, so that's aimed at the unions, whether by anyone, if they're able to. But then over the page at paragraph 3, you'll see that an order was also sought requiring that the defendants forthwith instruct their members to act in accordance with this order. So yes, it's right to say that it's not in terms of persons unknown, injunction, but it is not enormously far removed from one, in that it is addressed to a very wide range of people, including all of the members of all of the various unions.
No, I think that's right, actually. So it's not addressed to them, is it?
Which sorry, I mean addressed in a looser sense. So
Well, but that's critical.
yes, paragraph 3. If an order is to be made that the members be instructed to not to carry on the activities restrained by paragraphs 1 and 2, it must be right to say that the members aren't therefore thereby bound by the order not to do those things. But I think in my submission, the court, as obviously does make such an order, considers it is being drafted in sufficiently clear terms that it is proper to give an instruction that the members be instructed on this basis.
I mean, we had different sort of instruction. That was clearly on the basis that trade unions have a degree of authority over their members. Well, the members don't have to do it, but most of them will be doing it because the union was telling them to do it, or at any rate encouraging them to do it. If the union tells them not to, most of them wouldn't. That's quite a long way away from the terms of the court order.
Well, my lord, the instruction the unions are to give their members on the face of this order is not to
do all those things.
Not to do those things. And so it's not the same as the order being addressed to the members directly as
No,
the
it is,
defendants.
my lord, it's a rather crucial distinction.
It's an important
Because they
distinction.
wouldn't be in contempt of court for disobeying the union's instruction.
My lord, no. My point is a narrower one, that the judge in this case appears to have thought that instruction in these terms was sufficiently clear and certain to have been capable of comprehension.
Yes, because the reality, sorry, but I mean, let's be real about this. They wouldn't have sent out some missive to their members in the terms of this order. They'd have said, don't do this, that or the other at news groups' premises or near them. I mean, I don't think...
That may...
Whereas, the orders we're talking about, that's all the person's unknown hat.
My lord, yes,
Was the order made in the terms you
my lord,
just showed?
exactly so, yes, one
I've
doesn't see...
just split the head
Yes,
to
it's
230.
It's page 230G, and starting at F under the heading Form of Relief. And one point of significance is that the learned judge here was concerned by reference to the earlier decision of Thomas and National Union Mine Workers. The form of order should be as clear as possible. And then goes on to say, in substance, they're entitled to the relief claimed against the defendants, as sought, for example, in paragraph 1A, and are also entitled to the mandatory order in respect of 3. There will have been no doubt further drafting and so forth. My point is that, in principle, this seems to have been sufficiently clear and certain, or that to the extent that there's any further drafting to be do, it's point of drafting rather than points of principle, making it objectionable to refer to.
We don't know to what submissions he received.
What we do know is he's received many. If you look at the front page, page 181, and see the number of days that this notice of motion took to...
Yes,
And it's quite a long judgment.
very
too.
substantial. Yes.
No, what I meant was that we don't know to what extent people took points along the lines of how on earth is any layperson going to be able to understand this order, and what about intention?
We don't know. No, my lord. My point is, I think, a slightly different one, which is that the court appears to have been happy in principle to make orders preventing intentional conduct.
Okay.
The final point, just before we leave this judgment, if I may, is at page 204, in the context of the test for intimidation. And this is again in response to a point my learned friend was making yesterday about the need to prove damage. First point at B on the page, we get the confirmation point I made earlier that the tort of intention, so the tort is one of intention, the tort of intimidation is one of intention. But then at the paragraph starting just below F,
Sorry, which page?
page 204. Said that if a threat is little more than idle abuse and is not to be taken seriously, there would not be sufficient action for intimidation. Indeed, the tort is not complete unless the person threatened succumbs to the threat and damage is suffered, but it's clear that injunctive relief can be granted to restrain the unlawful act and also threats to commit the unlawful act. And my lord, in my submission, it must be right that the court can restrain somebody from intending to commit an unlawful act, whether or not
This is the point that my lord was making Miss Bremlow yesterday.
Indeed, my lord, yes. Well, given it was in the authorities, I thought it was maybe
Yeah,
worth having to reinforce that point. The third of the four cases it's going to take the lordship's to is that of Hubbard and Pitt, and we're back now in the core authorities bundle. At tab 2. And the brief facts are set out in the first paragraph of page 143, the second page of the report. And this was a protest by a group of, albeit named individuals, approximately 8 in number, who were protesting outside the estate agents on Up Street in Islington in protest about the changing social make-up of the area. You can see that there. Claim bought by the estate agents to restrain this conduct relied upon the tort of watching or besetting, and which is set out at page 180 in the judgment of Lord Justice Stamp, who I should say was in the majority of Lord Justice or Justice Leggatt dissenting. And you can see there by reference to the judgment in the J. Lyons case that the ingredient of the tort was that the truth is to watch or beset a man's house with a view to compel him to do or not to do what is lawful for him. Not to do or to do is wrongful without lawful authority unless some reasonable justification for it is consistent with the evidence. And so the point is there that this is an intentional tort. Conduct needs to be combined with an intention for it to be legal. And their lordships were, the majority were satisfied on the evidence that there ought to be an injunction. But then a point was made when it came to drafting the form of order as to what role intention should play. And that is dealt with in the judgment of Lord Justice Stamp, page 187. In the paragraph in the middle of the page, at C, as I hope is sidelined on your lordships.
Should we read the whole of that paragraph to ourselves?
And then and over the page to the end of A, please.
Does Lord Justice Orr address this point?
Lord Justice Orr addressed the point in effectively the same terms at page 190. Again, I've sidelined the relevant passage.
I know it stands for the proposition you can grant an injunction that's wider than the tort that might be committed.
An interim injunction.
this was a case that wasn't considered
Well, probably even a final injunction.
Yes,
The court has jurisdiction to grant an injunction to stop people doing something lawful.
My lord's probably right about that, but as I was certainly went through Lord Justice Orr's, he was talking about to impose an injunction which may, for a limited time, prevent the defendant from doing that which you'd otherwise be at liberty to do. As Lord Justice Stamp pointed out, interim injunction is often granted. I think he was making the point that you were making, that we slightly knocked you off it, that it made a difference that this was an interim injunction. That is certainly more comfortable than if there's a final injunction in the same terms.
My lord, the final case I was hoping to take your lordship to, which has been away the final piece of this jigsaw, if I may, is the Burris and Azadani case, which is at tab 4. And the facts can be seen the first paragraph of Master Roll's judgment on page 1374. Where it is explained that the appellant was the subject of an injunction granted in ordinary common law proceeding. With one of the terms of the injunction being that he shouldn't go within 250 yards of a specified address. He did so, which was proven he was committed to prison. And he submitted on appeal. The term in question was one that the judge was not entitled to impose, or should not have imposed, and sought to be released on those grounds. Then,
This was a good illustration of the point because, as I read it, the actual breaches which resulted in him being committed for contempt involved him bicycling within the 250-yard radius, but not actually doing anything to harass the claimant.
my lord, yes. And the analysis of the learned judge in that case started at page 1376 at H. Which starts by noting, of course, the very broad power of Section 37 of the Supreme Court Act. Before over the page, at the top of the page,
So on 138.
sorry, 1377.
Oh, yes, sorry, yes.
Could I simply ask your lordships to read down from A to G on page 1377?
And this was a final injunction.
This was a final injunction. And if your lordships have read that passage over the page at 1380, this is having considered the authorities as to whether or not there is.
Sorry, this was a final injunction, although the passage which Master of the Rolls cites from Croissant and Bush seems to be all about interlocutory injunctions,
My lord, yes.
but still.
The general principle there seems to be that for any injunction, whether it's interlocutory or final, there's a trade-off, if you like, between tailoring it to the specific wrong and making something that's clear and effective to prevent the wrong. And if making it wider than necessary doesn't involve a significant additional interference with the defendants, then that may be the appropriate thing to do.
Yep.
Didn't really prejudice him to stop him bicycling within 250 yards.
Yes, thank you.
So, my lords, it goes slightly beyond the need for a trade-off as between clarity or width and the broader point I made than what was put to me a moment ago. And then finally here was the point I alluded to earlier at page 1382 in the supporting judgment. Lord Justice gave rise to the imposition of the injunction no longer have any basis in fact sufficient to justify its
Yes, so in fact, you're, with respect, wrong. So when I said this was a final injunction, it wasn't. It was an introductory injunction.
Oh, sorry, no, that was my mistake. I apologise, my lord. So, in my submission then, to conclude my point here on this summary, such an imposition of my clients, that the court should be prepared to seek to grant effective relief, and if that may, to limited extents, for a limited period, at least for so long as it takes application.
Satisfied that it's likely that an injunction in these terms would be granted at trial. Well, so it's rather more than the Lord Diplock test in Cyanamid.
My lord, yes, that's an additional protection.
Made at final order will be made at trial in the terms, which would include a liberty to apply.
But my lord, that's
So really, what Lord Justice Sheeman said is actually quite important to your submissions.
albeit that I recognise that the likely test was met in this case, so appeal against that. And if it's two ways around, I think I made this point earlier, that if it was right that you never have final injunctions against persons unknown, then no one could ever show you were likely to get such relief at trial, and therefore
But
such
in this case, order clearly restrains unlawful acts, doesn't it?
Well, that's my submission.
I know, but all these submissions have been directed to an injunction which would restrain lawful acts.
Well, this injunction does restrain lawful acts in a limited way, that I drew attention to yesterday, in that there can be a breach of the injunction, even though there's no doubt which would constitute the tort of conspiracy by unlawful means.
All right, well, we had a discussion about preemptive injunctions.
It may restrain someone from attempting to commit an unlawful act but not succeeding in doing so.
Particular injunction, at least paragraph 7, has so many intentions built into it that it isn't clear and precise in terms of what it and except that, well, clearly the attempt in this case was to tailor the injunction as closely as possible to the tort. But the result of doing that, it was submitted in paragraph 7.
Which means that because different layers of intention need to be proven, it may be hard to prove breach in an appropriate case.
Well, that's one element, but the other element is it's quite hard for somebody to know very clearly.
In the same direction, they're not in conflict. And what in my the authorities tend to suggest that one authorities, which wouldn't take your lordship's just briefly. Device is a sort of intention, and then says this requirement may seem at first sight to be too narrow, not least because it might appear that it would.
Sorry, which paragraph?
112, page 156.
Oh, yeah, sorry.
So to here in my submission, where people are trying to flag down a lorry on a to be to say that if one certainty way, then in my submission, not so.
Okay, thank you.
So looking then, I don't know if your lordships will have it open, the committal ground 3, core bundle, tab 1, page 19, non-violent protest cases. There is then a summary between 19 and 26 of those protest cases. 27 to 33, 34 simply set out what options were analogous guidelines, and that's a manifest excessive test. Your lordships asked yesterday what the test is. It is by principle, regard by the judge to immaterial factors, or failure to have regard to material factors, or a decision which was manifestly excessive in the sense of being outside of the reasonable options. And the authority for that your lordships asked for is paragraph 44 of the judgment of the Court of Appeal in Liverpool Insurance Company against Zafar, and that's 2019 EWCA 392 Civil Division.
Paragraph
44.
What was the reference again?
2000. And one sees at paragraph 31, and then at E on that page, end of paragraph 32, the motivation of an offender can go to increase liability that forms no part of the court's function to adjudicate. Is the reference to the bargain or mutual understanding operates in those cases between proportion on behalf of those acting and the proportion of those sentencing. It's a well-known proposition in the second sentence that a community sentence with a punitive element involving work or perhaps curfew, justice, as has been remarked, a community sentence is a serious penalty. Moreover, if not complied with, the offender may be resentenced. So that's the point of principle then is about the protest in crimes committed protests don't receive high levels of culpability typically. With that in mind, I invite your lordships to turn back to the way that Honourable Judge Pelling dealt with it at tab 10 of the core bundle. He then notes in terms the submission made by my learned friend paragraph 2 that a benevolent approach should be adopted in protest cases, that it is wrong to say that a custodial sentence in the context of a peaceful protest is wrong, and also recognising correctly that crimes committed in the up to. And then the judge continues at paragraph 25 to set that principle of benevolence in a criminal protest case against two other factors. The first is there's been a breach of the court order, and in fact I did so in this case when making what became a July order. Now, the learned judge there is making the correct and uncontroversial point in my submission that it has already been considered. And then over the page of paragraph 31, this distinction is put into practice. And the learned judge, the second half of that paragraph, says that he's unpersuaded by the fact that the breach occurred while protesting was relevant to sentencing for civil contempt by breach of a court order. And the reason he is correct in principle is because in this case in particular order has been made to stop process. This is just protest.
But it doesn't follow from that you should impose exactly people carrying this out in the course of a conscientious protest.
My lord, I'm trying to think of an example where an order might be made in the context of disorder generally, and that was breached. But in the context of this order was made specifically because of protest actions, which have gone too far. And so it's rather seeking to re-argue a point which has already been determined by
Respected the rights of peaceful protest. But that doesn't mean that it's not relevant when it's broken. Take into account the fact that the people doing it are peaceful protesters.
My lord, the fact they're doing it by way of peaceful protest can't make their breach worse. Because that was exactly what was anticipated. But
And in pursuit of something that they very strongly believe, of course they strongly believe. It would be worse if they were doing it simply they wanted to create anarchy, let's say, or
personal dislike for the judge.
Exactly,
Yes. So the fact that it done in the protest context can't make it worse. There are other aggravating factors that one might take.
You're concerned with this sort of conduct in the first place.
Exactly so.
And in a sense, that is what he does say in the next sentence.
My lord, yes. Yes. And so even if the matter of Judge Pelling unpersuasive in the first line of that sentence was being too black and white about it, and was applying the wrong principle. In the alternative, as your worship says, it wouldn't make a difference anyway.
Yeah.
So it can't be said that he's got the principle that community orders are less serious than suspended sentences. In my submission, in quite in isolation, it's a slightly peculiar thing to say, because if a criminal judge has an open to him guidelines and how they ought to be, from the criminal context, how they ought to be applied here.
it may be true that where you don't have community punishment as or order as an option at all.
And actually, comparing suspended sentences in the committal context here and in the criminal context is also difficult in my submission, because the only condition to talk about suspended sentences in the abstract is not in my submissions very clear. Then that on to the final chapter, which is the reference to the sentencing guidelines for breach of criminal behaviour order, are the relevant guidelines to have regard to. But in my submission, the answer is pretty clear, and that is that what a criminal behaviour order does is make it a there was a detail between the parties which I touch on very briefly. The other, some adjustment needs to be made, some allowance needs to be made. In my submission, it's too simplistic, though, to say one needs to treat it as being about 40% of what you would have got otherwise. Rather, it means that quite a wide range of breaches of the court order might justify a sanction towards the top of that scale. So the point is a simple 40% or simple proxy division. And it's right to say, Judge Pelling didn't seek to apply a 40% deduction or a half deduction or anything of that sort. He did highlight the fact that it was a criminal context which didn't strictly apply. In relation to the 24th of July incident, the Lockdown incident was a B2, at the bottom of category 2, and that relation to suspended sentences of 4 weeks and an additional 2 months were manifestly excessive. I said the final point, saying the final point is one always thinks of one more. If I just may take your lordships finally by way of illustration, contempt of court doesn't really stand for that, and that is at tab 12 of the court, authority's case. Which says you could not do so. That is your saving grace, because I can tell you that now, had you contested these matters, and had there been a hearing before me, that outcome would have been very different indeed. As is, I'm willing to accept that you now do appreciate the gravity of what. This was right upon my learned friends for the proposition that courts can be very lenient, and this was an example of leniency. And the point I'm making is that it was a very different situation.
Yeah.
Well, unless I'm listening to both weeks.
Yes, 2 months to run consecutive.
Sorry,
To run, I hadn't, it's consecutive. Now, the point that I'd just like to raise with you is the justification for 2 months as a delay and so on to the claimant. The other incident, the jumping in front of the lorry, in fact, caused no sentence.
the justification, my lord, is what the judge perceived to be the danger of what was
But
being
what's that got to do with this injunction? I mean, that seems to me a highly relevant matter if this was before the criminal. But I don't know whether she was
endangering life or something. But
Yeah.
that's not.
When was Miss Lawrie prosecuted for that incident in respect of?
not to my knowledge.
But why is it relevant to the protection of the claimant's interest? I mean, that's the bit I'm concerned about.
I wasn't. Your lordship, the judge said about the danger of it.
Oh,
So
sure,
I take it
sure,
that
sure.
it's-
There was a
it's-
danger, for example, that some other user of the highway, either the lorry driver himself could have been involved in an accident, Miss Lawrie herself might have been, another road user might have been. These are all highly relevant matters to a criminal court on a prosecution. But why is it
being dealt with. That was point one. Point two is that the judge was influenced by the fact that Ms. Lawrie didn't appear to accept, or didn't accept, or apologise.
or was it just complete stupidity on her part, not thinking about what the consequences might be? So does the judge deal with
The latter, my lord, I believe expressly, although I can't. My lord, no.
So it could have been negligence.
My lord, yes, I don't.
Out of the last minute, there was clearly all these sort of risks, but there's no finding that those are risks she knowingly undertook. And in any event, why would that be?
Shouldn't it be limited to aggravation circumstances to be matters that are have a connection to the interests which the order is trying to protect?
Possibly not particularly aggravated, or could do it in a very dangerous way, and then refuse to recognise or decline to
Leave that bit
recognise.
out because that's just an extra complication. But
Obstruction is a problem, but you're also doing so in a way which is very dangerous.
well, in
But
a way,
that's directly connected.
yeah.
Because that, as you say, aggravates the inconvenience. Yes.
At which point there would have been
Yeah,
what
but,
refers very
but
severe.
to come back to your example, what might be necessary, as my lord points out, your example of the person who does a much more sophisticated. But suppose it's only, as in your example, danger to herself. Why would that be an aggravating factor? That's and if you're
To think two dark thoughts about this, but treat in any sense flippantly, but had somebody been killed or seriously,
Well, then the criminal law would undoubtedly have been engaged,
Yeah.
and that would have
Connection. But that isn't suggested here.
well, the intention there, my lord, was to stop the lorry, and that was done so blindly. I don't think I put it more highly than that. To the risks at stake.
It's on something which is really, as my lords have said, nothing really to do with the order, and was not, so far as we know, deliberate. They were not consequences which were deliberately, and to be heard to say that they weren't intending to damage the lorry and understanding the risk of injuring the driver if you threw a concrete block at the windscreen. I mean, it's a different point if you run in front of it, you do something exceptional.
And that seems intuitively wrong. Well, we've probably explored that.
Can I just mention one other point on this? And that is looking back at the liability. None of what we've just been discussing features in that. The judge then adds it.
Yes, the judge.
Was he entitled to do that?
Yes,
Was it part of the charge against this lorry that she had endangered life and so on?
He was being dealt with in a alleged that was there was
All right,
evidence
so that was
of
something
what was done.
I see. Did you press this on
It's
him
fair to say that
as an aggravating factor?
no, it's fair to say that I didn't press for any particular. It's fair to say that the learned judge was very concerned of his own motion about
This.
misconduct.
So this was really the judge's point rather than yours.
Yes, fair way.
Thank you very much.
Simply before I leave that point, if we may, the other reason that the judge will have had regard to that factor because of the common ground that he should have regard to the sentencing guidelines, which do include
Risk of harm.
risk of harm.
For that it's appropriate to include intention within an injunction because it's used within criminal law quite rarely it's suggested without difficulty, is set out in fact advised by Parliament and the courts. An injunction, by contrast, and in this case what we're concerned with, and this is a big difference as well, is it's the person's unknown or the court by way of case stated, and it's an obstructing the highway case. But because that's a criminal process, part of what the police did when they interviewed that, unless they move away and they're given, it literally is a 5-stage test, they're given various opportunities. The final one being, unless you do this, we now are going to arrest you. And then the first they know of it is when there is the application for them to be committed, which is exactly what happened in this case. The application is then
That can't
made.
be right. There's a finding that they knew about the order.
But they don't know, and the example is in Ziegler, that's a very similar type of case, an obstruction of a highway type case. Here, the person is at risk of criminal to the recent earthquake or tremor, for example. They do not know at that stage, well, we'll give a warning that your intention, we're saying, does breach things around interference with peaceful protest in criminal law before the case even gets to charge. And obviously this is even more committal on the breach of 7.2 was only in relation to Lawrie, and there was no finding of breach of 7.2 in relation to Mr. Wilson. Persons unknown.
So just before we go into any more detail on this, how does this arise by way of reply? I understand what it's plugging into.
Yes, the reply deals with the submissions.
The decision on the basis of it falling outside the description of the person's unknown.
I accept it's not in the grounds, and if it's a matter the court doesn't wish me to address, I won't. But I take it from the submissions yesterday.
We want to hear
The submission on INEOS as set out by Mr. Roscoe yesterday. Our submission is principle, and in particular, which is relevant to the submissions that have been made, starting at sub 3. It is possible to give effective notice of injunction for the method.
Have cited to us Burris and Adzani or any of the cases in that line of authority, and subject to any submission make now, it seems to me that statement in the absolute terms it was expressed in INEOS.
So, and I can take you to Canada, which is at tab 14. Page rights was made in paragraph 83, and over the page.
Sorry, just give us a moment. I just want to see the context. So the context is at 80, which is a paparazzi photographer's case, and Smith, again, which we have. Then he sets out the fact making. So what's your submission?
So the submission in relation to that is that this Burris was a very different type of, as distinguished there, of significance was, firstly, this was a named person. It was not a case that engaged rights of freedom of expression or freedom of assembly, as in this case.
Well, I mean, you rely on what Mr. Justice said in paragraph 86 for distinguishing boroughs.
Absolutely. Yes,
There can in principle be no
I think it was at the time before the convention had been incorporated
True.
in English law.
Absolutely, it was pre-Human Rights Act,
Yes.
and different laws apply.
Even if that would be necessary in order to make the prohibition effective.
Because the tort, partly because it's freestanding, suggested by the respondents, is that once you're at court, you could then argue that your behaviour was lawful. And in fact, before that, they put forward that these interim injunctions can then be used to chill peaceful protest, to chill lawful behaviour, knowing that the citizen is not going to take the position of a peaceful protester and the freedom of expression and freedom of assembly. Those people are in a very different position to the cases like Burris, the non-molestation family cases where somebody is named within the time that we are in now, and with the common law as it's developed since Hubbard and Pitt. But certainly that is the case Cuadrilla seeks to rely on. The precise as to enable persons potentially affected to know what they must not do, and we've had the point on the temporal limits. The position, of course, on the temporal limits, as was addressed, 2 years, with some comfort that a person unknown is unlikely to be coming back to court challenge it, because they don't know that they might be with a relationship between the threatened tort and the injunction must be a strong one. On intention, on uncertainty, the point as raised, it's referred to, it's from paragraph 23. 4 and 7 was sufficiently certain.
Yes, sorry, I thought you were, because this is a reply, I thought you were the point he made on the liability judgment, and we're going to say why the point was not a good one, and you referred us to paragraph.
On dealing with uncertainty that the respondents hasn't tackled, is that both those paragraphs, the one which paragraph 4 is identical to, and paragraph 7 is similar to in all material respects, with that they were too wide rather than being unclear. However, that is not what Lord Justice Longmore says in INEOS at paragraph 39. And Mr. Roscoe referred today to paragraph 38 of the sanction judgment by Lord Bridge.
Sorry, where were you referring to?
It's in the 3rd of September, page 140, paragraph 38.
Liability
It's 28 of June,
Yes,
my mistake.
yes.
It's tab 8.
Yes, thank you.
I've taken them out of the file.
Yes,
that's
well,
why
it's my fault.
I know.
You're being very kind. I was.
Don't worry. But anyway, we're all.
Is that, and as was discussed yesterday your lordships and Mr. Roscoe, is that intention and a natural consequence of your actions. So therefore, he made the finding that although he accepted that they intended to protest, he made the finding that they also had the intention. On the committal order itself, just moving on from that, and we carried out further research overnight and obviously considered the...
Right about that, if you
Yes.
put it right, as far as one can ever discover these things. It's not the first time an order has been made,
No,
because it was made from Stratford and Lindley, and
Yes.
yes.
prior on the
Such an order was made. I think such an order was made in Stratford and Lindley, wasn't it?
the persons unknown
I think
that come back and forth on this
Yes.
litigation, challenging the tort and seeking to vary it.
Well, perhaps it's a necessary for us to debate the history very much, but
that's
no
not-
doubt.
Mentioning of criminal law and enforcement through the police and so on. And Mr. Roscoe's submissions today came very close to say damage, and none of that was looked into when the order was granted.
I think we are risking a long way
We're
away.
probably moving away, but that's one of the issues of economic tort. It's very resulting in something which is at the criminal, at the custodial level, and that the highest punishment there was a fine, and that was a clear deliberate breach.
Yes.
The submissions made by the respondent seem to be that His Honour Judge Pelling had applied the protections that he has to apply by reference under Articles 10 and 11 by reference to Blevins. However, we submit it's very clear that he considered that they did not apply at sentencing stage, and in fact that also was a submission of the respondents, that it does not apply at sentencing stage. But what he did say in paragraph 13 for civil contempt by breach of a court order, if I'm passed, or that I should impose sufficient application of particular whip. The starting point, as was accepted, I'm sure, yesterday, but it hasn't been, and this is very clear that section 6 and the respondent
Yes, thank you.
and so it sets out there that even a significant consideration is not that endangering and so on, and aggravation has no part within the breach of the breach is found at clause 7, but it also underpins the issue which
Well, you
is
can't
to
have it both ways, as it were.
regulate protest.
Either it doesn't apply, or it does, in which case it might be an objection to the injunction. But
It's it goes. I think we can have it both ways, but the submissions are there. It's uncertain. It's an use of an economic tort, and that the end result of how this has ended up with this sanction in this way shows how far away it's come from something which is an unlawful means economic tort, and that really underlines the danger and the chilling factor of both of using an injunction in this on peaceful protest.
Need not attend, but in advance of that, copies of the court's judgments will be circulated for typographical and other corrections, and also importantly so that the part of the hand down, as I explained yesterday, we will be dealing with the permission to appeal application relating to the cost according to in the ordinary way.
Point to be dealt with at the same time, at least, as the consequential matters from the costs of this appeal. yesterday, potentially the same, which is that
handing down of this judgment or for dealing with that application, but we will bear in mind very much the likelihood that there may be common issues.
but also asking for my respondent paragraph,
Yes.
paragraph to my head, and ask for it to be done in a short-ish time frame. What sort of time frame did your lordships?
Well, we rather trusted you as quickly as you could, Mr.
Yeah.
Ross, to put a timetable.
If you had something by the end of the week, would that suffice for your lordships?
That would certainly suffice, yes.